So tell me, why do we permit taxing of individual partners when either state law or their partnership agreement doesn't realize the income to them? In many states, a partner doesn't have personal ownership, doesn't get the value of the partnership, yet we've permitted that tax.
Thank you, Justice Sotomayor. A partnership is a fundamentally different form of organization than a corporation. The law has always recognized that a corporation is a person separate from the shareholders in that corporation, and there simply isn't that separate personhood that applies to partnerships. The partnerships are simply a group of people who come together to undertake a business activity, and when they do so, the income that comes in to them is their income directly.
So what do you do with subpart F? Or subpart S, or all of the other ways in which we have attributed corporate income to individuals? You don't challenge the constitutionality of subpart F.
That isn't an issue in this case.
But in your brief, you don't appear to be challenging it.
We think that subpart F follows the commonly accepted method that Congress has used to address situations when a taxpayer has interposed a corporate structure between themselves and income that is otherwise theirs.
But that's the whole purpose of a corporate structure. People do that all the time, particularly for that purpose. You don't incorporate unless you want the corporate shield. You don't incorporate unless you want the benefits of the corporate protection. So under your theory, subpart F, subpart S, these are long-standing taxing mechanisms by the government. Your theory would undermine those as well, wouldn't it?
I don't think that's right. Subpart F, again, works on simply categories of income on a current basis where those categories of income are properly viewed as being, and Congress determined, are properly viewed as being earned by the shareholders due to the nature of the categories of income that are addressed by the statute.
I'm sorry, go ahead.
So you concede that subpart F is constitutional. I just want to be sure that I understand your answer.
We think that the defect with the MRT doesn't really apply to subpart F. The court has never considered the constitutionality of subpart F, but as we take it, we don't think that there's a constitutional issue.
So what is the distinction? Is it just that other parts of subpart F, to the extent that they tax income, do it on an annual basis, and the MRT was a one-shot that went backwards?
I think that's part of it. But again, I think what it really is that that subpart F addresses this fundamental income shifting concept, whereas the MRT doesn't, and that's so in two respects. First of all, subpart F operates on a current basis while the corporation is subject to the control of the controlling shareholders, whereas the MRT takes no account of
I'm sorry, there's no question that you meet the definition of subpart F. You need, in subpart F, at least 10% of the company share, and the company has to be owned more than 50% by U.S. owners. So it's identical in terms of the percentage of ownership or the percentage of shares.
That's right, but subpart F, unlike the MRT, aligns the control and the ability to redirect income with the year that it is applicable to. The MRT takes account.
It sounds to me that what you're attacking is only a due process issue of how long the tax is for, not the ability to tax.
I don't think that's right for the reason that I think whether you owned a particular piece of property on a given date, which is the question that the MRT asks, is sort of the sine qua non of a tax on property, whereas subpart F looks at income as it comes in while the controlling shareholder has the ability to redirect that stream of income.
But isn't that then just a question of whether it's fair to attribute, fair from a due process point of view, as Justice Sotomayor is saying, whether it's fair to attribute the income generated by Keisencraft to the Moors, which is a distinct question of whether there was income within the meaning of the 16th Amendment, right?
Well, I think it ultimately comes down to a 16th Amendment question for the same reason that the court thought so in McComber, which is that a shareholder's interest in a corporation, including in its income, is a capital interest and therefore a property interest. And so if there is some reason to look beyond that and attribute income to the shareholder, that would necessarily raise a question of income and why it is that the shareholder isn't being taxed on what would otherwise be a property interest. So I think the court has always addressed this sort of question as a question of income, and that includes, for example, all of the assignment of income cases that the court has decided over the years.
Can I go back to first principles? The concept of realization was very well established at the time that the 16th Amendment was adopted. But the amendment does not reference realization. All that the drafters had to do was add the word realized after income to lay and collect taxes on income realized, but they never used the word realized. And then I look at the history both before and after the ratification. As far back as 1864, not so far back, Congress taxed from the ratification. Congress taxed, quote, gains and profits of all companies, whether incorporated or partnerships, in estimating the annual gains, profits, or income of any person entitled to the same, whether divided or undivided. In 1913, just 8 months after the ratification of the 16th Amendment, Congress included undistributed corporate earnings to certain shareholders. Your brief tries to distinguish all these things, but I come back to the main point. Both sides can point to congressional actions that taxed some realized income, some or didn't tax unrealized income, but we have examples of Congress taxing unrealized income. Why don't I take it that the plain text of the amendment doesn't make reference to realization?
I think there are two central features of the text of the amendment that reflect that it does apply only to realized gains. The first is simply the use of the word income. I would particularly commend to the Court's attention the amicus brief filed by the professors of law and linguistics, which analyzes the use of the word income in period text.
As I go back, all of this goes back and forth because the government has other definitions. We're back in square one if what we're doing is weighing historical definitions.
The weighing in this case, Your Honor, is quite lopsided. The government relies principally on two definitions that were put forward by economists in the years following the amendment's adoption, and neither of which reflects the common understanding at the time. One of the economists recognized that he was simply espousing his own economic views, divorced from any question of law or common understanding. And the second economist recognized that the common understanding of income is what we say that it was, a realized gain. So far as the common understanding of the term was concerned, the only indication that the Court has before it, aside from dictionaries which, again, lopsidedly favor our position, is the corpus linguistics analysis of the professors of law and linguistics, which looks at how the word was used in everyday language at that time. And it concludes that unanimously, where it's possible to distinguish, income meant realized gains. There's also in the amendment the language from whatever source derived. As we pointed out, derived was generally meant to refer to concepts like receipt. And indeed, again, the amicus brief of the professors of law and linguistics recognized that when income was described as being derived, it was always used in that fashion.